because I think even if we look at the extraordinary renditions program itself, I can sort of understand the methodology of the legal reasoning that's involved. Well, this is not really in the extraordinary renditions program where someone's being rendered to a country that cooperates with the U.S. in intelligence. It's a country that is essentially, that harbors terrorists and is essentially an enemy of the United States. I think it's been defined that way quite sharply in the past. But, I think that the rationale that must have been applied here was one where they expected some level of cooperation with Syrian police authorities. They expected an aggressive interrogation, potentially using prohibited techniques, highly coercive techniques, and their legal analysis led them to believe that a highly formalistic assurance provided by Syrian authorities that they wouldn't torture, even if they didn't believe that assurance deep down inside, was adequate. So the attitude seems to be, don't really probe, don't ask a lot of questions, don't do any.
Don't ask, don't tell.
Worse than that, even. Just get them to say something to you and go on that basis. And that seems to me to be playing fast and loose with the statute and the requirements of the statute, because the statute, basically puts forward the test of more likely than not that the person will be tortured. I mean, diplomatic assurances are, under the regulations, they're permitted as a route that can be pursued, but they don't overcome this basic requirement of a determination that it's more likely or not. And I cannot see how the Attorney General could reach a determination that it was not likely that Mayor Arar would have been tortured on rendition to Syria under all the facts here.
Is there a formal process, I'll address this to Mr. Skinner and Mr. Irvin and to you, Mr. Horton, that describes the procedure of securing diplomatic assurances? Is there in existence a Department of State protocol or series of regulations that would clearly enumerate the steps to be taken to secure diplomatic assurances?
Yes, there are, and I believe we do comment on that in our report. There are processes that you would ordinarily take to obtain those assurances.
Were those assurances complied with in this particular case?
It doesn't appear that before, I don't want to draw a conclusion that they were or were not, but it certainly, from the information we have, does not appear that they were followed to the letter of the law or the regulation. But we have to keep in mind that in this process, there's two different processes that we could take here to our proceedings. One I referred to earlier as a 240 proceeding, which is not necessarily deals with terrorists per se, and then there's the 235C proceeding, which does in fact deal with terrorists, and it's somewhat nebulous as to exactly what process you must follow to obtain those assurances. So there is some flexibility there.
Let me go back to a question that was posed to you earlier about the requirement of the statute that a report to Congress after 7 days in the event of an apparent deficiency or lack of compliance. Why wouldn't the Office of Inspector General have reported to Congress, to this particular, to the Committee on the Department of Homeland Security or to the Judiciary Committee, this deficiency, given the serious nature of and the consequences that we've endured since?
Let's keep in mind that the department did reach out and to obtain assurances, and then and leave it. We could stop there. The question is the question is whether those assurances were sufficient.
But that's my point, Mr. Skinner. What I'm suggesting to you, from my perspective, and I'm becoming somewhat conversant with the details of this case, I would suggest that on their face they were insufficient. And I would suggest to you that it was the responsibility of the office not to report necessarily to the Secretary of the Department of Homeland Security, but to this institution. Because we're in this together. You as Inspector General and Congress as an institution with the constitutional responsibility of serving as a check and balance on the executive branch. We have been in the dark on this particular case since the incident occurred. This is a gross embarrassment to the people of the United States and to this institution. And what I would hope is that you and Mr. Horton and Mr. Irvin and others would make recommendations so that we could clarify the responsibility of the Inspector General to report to the relevant committees of this institution where there are areas of significant concern.
Chairman, we did in fact report to the department through our report, and immediately followed that up within 7 days, I believe 5 days actually, with the report to the Congress. Now, as far as when we say reporting immediately to Congress on flagrant violations, what we're talking about here is an event that had occurred 3-4 years earlier. We did not find during the course of this review that the practices that were applied to the Arar case was still ongoing. And if it was, then of course we would have done a flash report immediately to the Secretary, then who had an obligation to report that to you. But we did not find any evidence that there was any flagrant or serious rendition activities involving the various elements within DHS. That would be ICE, CIS, and CBP.
I note the appearance of Chairman Nadler, and I'm going to turn the gavel back to him and excuse myself. I want to thank the panel. It's been informative, but it's been very disturbing to hear your testimony. And this is a matter that we have an obligation to pursue. And given the delay that's already occurred and the penchant for secrecy that appears to color this particular case and other situations in the administration, my recommendation for a special prosecutor to be assigned will continue that secrecy with the convening of a grand jury, so those who are concerned about secrecy can give their testimony to a federal grand jury behind closed doors. And with